Welcome to the Magna Carta Prelims 2024. This is lecture number 4. In lecture number 4, we're going to be covering two topics, territory and citizenship. Now, both of these topics at the very beginning are extremely low frequency topics as far as the prelims is concerned. In the last 10 years, there has not been a single question from territory in the prelims exam. However, in the last 5 years, there has been one very basic conceptual question from citizenship in the prelims exam. So in 2024, we have to keep in mind the trends of the paper and cover this topic with a fair degree of restraint. Just in case, if you'd like further details on this topic, you're more than welcome to download my specific Magna Carta foundation notes from my Telegram channel if you'd feel like. Now coming back to lecture number 4. We'll largely be covering two parts in lecture 4. The first is dimensions and policy of territory, and second, dimensions and policy of citizenship. Now, though there has been no question on territory, there have been questions on dimensions of territory, more specifically with respect to UNCLOS in the last 5 years or so. So we'll have to keep that in mind as well. Let's begin with the first part of the 4th lecture, which is dimensions and policy of territory. The first part that we've got to understand is the types of territory and the layers of it. So to begin with, you've got 3 basic types of territory, which is land, water and air. So any discussion on territory would eventually begin on the types of it, and each of these 3 types are going to have 2 layers to it. One would be an external layer, the second would be an internal layer. An external layer is largely a national or an international layer, and an internal layer is a subnational or a subunit layer. Now, when we speak of land, we understand from an external point of view, there is essentially a political dimension to external land and an economic dimension to external land. When we say there is a political dimension to external land, we are effectively referring to the international land boundaries that have been defined for India. And India's international land boundaries have largely been a result of the partition of India and a result of India's colonial history. So therefore, our international territories or our national territories have largely been marked for us by our colonizers, the very British. In addition to this, due to the partition, we've also had a significant change and a significant redrawing of our international or national territory. Even the partition and the territorial division of the partition was actually executed through the British. So that's something to remember. From an economic point of view, you are very well aware of national income accounting. And in national income accounting, there is a concept of a national territory of India and the domestic territory of India. The domestic territory of India is the physical land boundary of India, whereas the national territory of India is the territory that ought to be of India. So for instance, the US Embassy in India is a part of the domestic territory of India, but the national territory of the US, because there is an economic bifurcation. Similarly, when somebody from India decides to go abroad and send money back to India, so that person's sending money back to India is added to the Indian income. So what happens is, if you want to go from domestic to national, you add what is called a factor income from abroad. So that's an economic way to look at it, which is beyond the purview of this class. So when it comes to national territories, we have very clearly identified our international borders. And whatever India is rightfully claiming to be its international border is in fact our international border. Now, it is important because when we discuss international territories, we also sort of get into the concept of what is a disputed territory. Now, it is very important to understand that a disputed territory would be a territory only for two reasons. One, if India has accepted foreign intervention and a discourse or a discussion on that territory or negotiations on that territory are happening at an international forum, or two, India officially recognizes the territory to be a disputed territory. So to make myself absolutely clear, whether it is the area of Exai chain or it is the area of Pakistan occupied Kashmir, or as it is called colloquially Azad Kashmir, these are all parts of the national or parts of the territory of India. They're all parts of the physical territory of India. There are no two doubts about it, because we do not recognize POK or Exai chain as a territorial dispute in any form. There is a possibility that Exai chain is administered by China, is occupied by China, but that does not mean the territory does not belong to India. Now, once you have looked beyond, we now look inside. So the first thing that we do in India is we have a political division. And this political division is that we divide India into states and union territories. Now, what is important to note is, as far as part 1 of the Constitution is concerned, which takes care of union and territory, what we specifically refer to is the international territory and, of course, states and union territories. Categorically, part 1 does not deal with any other form of territory. Now, within these subnational units called states or union territories, or these provincial units called states and union territories, you can have an administrative division or a representative division. A representative division could effectively be an MP or an MLA constituency, whereas an administrative division could be a district, a sub-district, a block, or a village. Sometimes a combination of administrative divisions could be integrated into the third layer of government, which is local self-government, and you could have urban municipalities and rural panchayats. So therefore there could be a rural and an urban bifurcation. Similarly, you could have some specific territories identified for dedicated welfare. For example, there could be an issue of, say, the 5th schedule or the 6th schedule, or say special states, or say special areas under Article 371A onwards. So these are subdivisions which of course in some cases the Constitution deals with. But those parts are not dealt with as far as part 1 territory is concerned. Having said that, you can also have certain territories earmarked for security reasons. For instance, a fairly discussed law called the Armed Forces Special Powers Act also calls for a specific territory or a specific division of territory or demarcation of territory called a disturbed area, which can also be earmarked as a territorial division but based on security. So there could be multiple ways to look at internal land territory. And in fact, because land is the most tangible, what effectively ends up happening is it is easy to identify different forms and layers of territory because it's easy to physically bifurcate as far as land is concerned. Then you have waters. Now, waters could be international waters and national waters. As far as international waters are concerned, there is a UN treaty called the UN Convention on Laws of the Sea. The UN Convention on Law of the Seas is something that India has ratified to, which means India abides by the international division of international waters. And I have simplified a bit. There has been a prelims question from here before as well. There are largely 4 types of international water boundaries, and these are calculated in nautical miles, which is about 1.5 to 1.8 odd kilometer. The number is not important, but they're calculated as distance from the coastline. So the closest to the coastline is territorial, or it's called territorial sea. Now territorial sea is full sovereign territory of the country. You could in fact even call it like the domestic territory of the country, which means in the territorial sea, which is about 12 nautical miles from the coastline, what you would generally observe is that all domestic laws, all domestic applications would be completely compliant. And while yes, foreign vessels do have the right to pass through the territorial sea area, but in international law, you call it an innocent right to passage, that you're passing through just because you're passing through, and there are no larger ideas or funny thoughts while you're passing through the territorial part of it all. If you go another 12 nautical miles beyond this, which is about 24 nautical miles from the coastline, you would enter what is called the contiguous zone. Now the contiguous zone is slightly diluted than the territorial zone. What happens in the contiguous zone is that it has limited jurisdiction of the country, which means the country will have jurisdiction largely for criminal law enforcement, for upholding certain basic law and order norms. So for instance, you could have the country supervise over customs, over violations of certain rights, over human trafficking, immigration, even taxation provisions, and also polluting elements. So all of the local laws concerning customs, trafficking, immigration, taxation, and pollution would apply till about 24 nautical miles. So you would still have some form of national sovereignty, a very important form of national sovereignty, but still not full national sovereignty. If you go a little beyond and you reach about 200 nautical miles from the coastline, what you would enter is called the exclusive economic zone. Now the exclusive economic zone, as the name suggests, is economic in nature. Now this means the country would have exclusive economic rights over natural resources. Now these natural resources would effectively include things like fishing, things like mineral exploration, and so on and so forth. And if you go further beyond, you entered what is called high seas. Now high seas is a concept which is beyond UNCLOS, which means that it is generally considered to be an entity or a resource equally shared by all countries. And as far as high seas are concerned, you have a dedicated organization, very important from an environment point of view, called the International Seabed Authority. The International Seabed Authority identifies this area, in fact, as the area. And in this area, you would generally have commonality of resources, commonality of ownership, and of course, commonality of responsibility to ensure that there is no over-exploitation in any manner. None of this is referenced in Part 1, Territory of the Constitution of India. When we look at internal waters, we would largely be looking at water bodies. Now what generally happens is, internal waters in India tend to be a federal issue. Now when we say it tends to be a federal issue, it means there are often times where a river would flow from one state to another, and we have historically seen several river water sharing disputes between the center and the states, between the states in fact, and the Constitution very specifically sets up an interstate water disputes tribunal. There was a law also recently passed, and the tribunal specifically prohibits the intervention of the Supreme Court when it comes to interstate water disputes. You can go to the Supreme Court if the order of the tribunal is not being enforced, but the Supreme Court directly does not hear or does not have jurisdiction over interstate water disputes. But any other interstate dispute technically is the original jurisdiction of the Supreme Court. Now, this becomes extremely important. Again, Part 1 of the Constitution, Territory of India, does not deal with these internal water sharing issues. They are dealt with separately in another part of the Constitution, fairly close to federal and center state relations. Now, because we live in a globalized world, there is of course the third element of territory, which is air. Now, air becomes an important notion, especially from a geopolitical point of view. And there is something called the Chicago Convention, which identifies what is called the national airspace. India has also ratified what is called the Chicago Convention. Now, the Chicago Convention identifies what your national airspace is, which means if there are two countries which are neighboring, and let us say the ties have roughened up, then what generally happens is the country closes down their airspace for the other country, which means flights cannot originate from these, and maybe you'll have to bypass the airspace of the country, which is one of the fundamental reasons why airspace becomes a very important instrument in geopolitics. As far as local airspace is concerned, or federal airspace is concerned, there is no such concept. However, because air tends to get polluted, you would hear of issues like stubble burning, where states would be blaming each other for these cases. But that's not from a legal point of view. That's largely from an environmental point of view. That's largely from a policy point of view. But this is generally the makeup of what effectively is called the dimensions of territory. Now, once we understand the dimensions of territory, we must be looking at the layout of it and certain key concepts, which is a part of policy overview. Now, this is conceptual and therefore needs to be paid attention to. When we refer to the constitutional layout, it means how the Constitution has dealt with territory. Part 1 of the Constitution is titled Union and its Territory, and Part 1 contains 4 articles, Article 1, 2, 3 and 4. These articles can be called enabling provisions, which means they give you the terms and conditions, they give you the do's and don'ts, they give you the procedure to make territorial changes. So when you make territorial changes, you don't change 1, 2, 3, 4. What happens is, because of 1, 2, 3, 4, you change something called Schedule 1. Now, Schedule 1 will contain the names of states and union territories along with their area, and that's pretty much it. So the actual territorial change would effectively happen to Schedule 1, and that's a very key concept, which leads me to certain key points. This means, as I was saying, all territorial changes effectively happen to Schedule 1. In fact, Articles 1, 2, 3 and 4 have remained unchanged since the commencement of the Constitution. We have added Article 2A and then we have removed Article 2A in the context of the nature in which Sikkim became a part of India. So when we added Article 2A, Sikkim had become an associate state of India, but when Sikkim became a full-fledged state of India, you had to remove Article 2A so that the Sikkim would become like any other state in India. So Articles 1, 2, 3 and 4, as I said, are enabling provisions that allow you to make changes to Schedule 1. So all territorial changes, whether it's external or internal would effectively happen to what is called Schedule 1. Now, if you could apply this a little bit more and correlate it to your sub-national political divisions, which means India basically is comprised of states and union territories. So whatever the territorial change might be, even if you're bringing territory from outside, you would either add it to a state or make a new state, or you would add it to a union territory or make a union territory. The change that would actually happen would be to the territory of the state or the union territory. So therefore, it becomes extremely important to understand that all territorial changes happen to Schedule 1. And no matter what the reason for the territorial change might be, the change would effectively happen to states or union territories. Now, different types of territorial changes would require different procedure, and that's something that we will get into. And this different type of territorial change is specially to deal with when we give away a territory to another country, or a specific type of territory to another country. But this would require a different procedure. Where would the change still happen? The change would still happen to Schedule 1 and nowhere else. So all changes happen to Schedule 1. Depending on the type of change, you will use a different majority, but the change will always happen to Schedule 1. Now, because of a trickle-down effect, this territorial change could often lead to other changes, which means when you're adding or subtracting the territory of the state or the union territory, which is a political territory, it could have an impact on the representative territory. So if you're dividing a state into two, you would effectively also be dividing the number of representative constituencies. And the Constitution very specifically mentions one kind of representative constituencies, which is Schedule 4. Schedule 4 contains the number of seats that each state would have to the Rajya Sabha. Now, if you're changing Schedule 4 for territorial reasons, for example, you are bifurcating Andhra Pradesh into Andhra Pradesh and Telangana, this means the number of seats Andhra Pradesh had to Rajya Sabha will decrease, and the number of seats that Telangana would have to the Rajya Sabha, obviously from 0, would increase. This would also require a change to Part 4. But this change to Part 4 is not because of anything else. It's because of a territorial change. So if it is because of a territorial change, it means it will be dealt with the same procedure of a territorial change. That's the key part. So often you'll see the same Reorganization Act would change Schedule 1, and because of Schedule 1 will also change Schedule 4. But if you remember the majorities lecture, if you are changing the number of seats to the Rajya Sabha for any other reason, for example, you change the criteria, you change the formula, then of course it would require special majority 3. But if the change to Schedule 4 is because of a territorial change, then the change would in 99% of the cases be a change through simple majority, an ordinary territorial change. So that's the third concept that we must be aware of. And fourthly, and this is the important part, territory is an instrument of sovereignty, which basically means when we are dealing with the notion of state, and we've discussed the modern notion of state includes territory, sovereignty, government, and people, which means territory and sovereignty are closely interlinked. Territory and sovereignty will have a very close association. So this means any change of territory is effectively having an impact on what is called sovereignty. So this means a territorial change could also be looked at from a breach of sovereignty perspective. So if a territorial change could be looked at from a breach of sovereignty perspective, and the word sovereignty is only and only mentioned in the preamble, it would lead to a larger discussion on the status of the preamble, on whether the preamble is a part of the constitution or not, which is why territorial changes which affect sovereignty have an impact on the meaning of the word sovereignty, which is in preamble, which is where you have a larger question whether the preamble is a part of the constitution or not. And that is why when you hear of cases like Berubari Union, in the Berubari Union, you will see the case to be significant for territory, but also to be significant as a milestone to determine whether the preamble was a part of the constitution or not. So that is the duality of the role of territory. It helps you understand territory, and it also helps you understand sovereignty and whether the preamble is a part of the constitution or not. So there are some key underlying concepts, and these concepts are enough to make you generally understand how things have to be executed. Now, let us look at the overall policy and the law and the procedure for territory. And let's go through it one by one. This is the law part, and this is the procedure part. As I've mentioned before, when we are categorically referring to law, part 1 of the Constitution deals with territory, and part 1 comprises of Article 1, Article 2, Article 3 and Article 4. Article 1 and Article 4 are referenced to Schedule 1, because Schedule 1 contains a list of the names of the states and union territories, and also contains a list of their areas. And because of a change in Schedule 1, there could be a consequential change or a correlational change to Schedule 4, which contains the number of Rajya Sabha seats to the center. Now, this is an outstanding application of rule number 2, center stronger than the states, wherein the constitution specifically mentions the number of Rajya Sabha seats to the center, making sure that there is a degree of legitimacy and mention in the supreme law of the country, which is the constitution itself. The irony, of course, is that the Lok Sabha will have certain overriding powers over the Rajya Sabha in some cases, and there is no concept of a political majority whatsoever in the Rajya Sabha. People can come from political parties, anti-defection law will apply, but there is no leader of majority, or there is no need to establish political majority as far as the Rajya Sabha is concerned. Now, Article 1 effectively talks to you about 3 things. First, it says India, that is Bharat, which essentially identifies nomenclature for us. 2, it then says India is a union of states. This is reflective of rule number 2, the center stronger than the states. So this means that unlike the US, where British colonies came together in 1776, declared independence and said, we are now going to become the United States of America, it was actually quite the reverse. We were British India, we underwent through partition, then we became what is called independent India. We integrated princely states into India, and we've been on a consolidation exercise ever since. So it is truly reflective of our political reality that India is a union of states, which means effectively in India the union came before the states, in the US the states came before the union. It also is reflective of a very important part, that unlike the West or unlike many modern democracies, our sub-national units, our states, have absolutely no right whatsoever to want to leave India, to secede from India. There is no provision whatsoever in any form which allows the states to even initiate a procedure to want to leave India. Any territorial change is effectively at the helm of affairs of the parliament eventually, which is of course a central authority or a national authority, which is why it is often colloquially said in a lot of textbooks and judgments that India is an indestructible union of destructible states, while the US is a destructible union of indestructible states. Well, more on that later. So, the fact of union of states effectively represents what is called a national character, a unitary federal character, and it mentions what is the territory of India. This territory of India, as mentioned in Article 1, is going to be referenced in so many different parts. For example, when we look at Part 3, there are going to be references to the territory of India. The territory of India is territory as per Part 1. So therefore, the territory of India includes states, union territories, and anything that we may acquire in the future. Now, what does this mean? States and union territories is fairly sorted. What is not sorted is the larger discussion on what can you acquire in the future. Now, let me be very clear. The Constitution or any law in our country does not give the power to anyone to go acquire any territory, because acquiring a territory would mean breaching somebody else's sovereignty, and it is a principle which is not particularly appreciated or liked in international law. So therefore what happens is we only look at the procedure. We only look at, you know what, you've acquired territory, we don't care how you've done that. Now that the territory is acquired, this is what we do to integrate the territory into India. So which basically means that we are effectively talking about the procedure of integration. We are not referring to the power of acquisition. I'll be very clear about this and repeat myself. We do not have the power to acquire any territory. It is a perverse idea under international law. What we do have are provisions that once the territory has been acquired, this is how we can make the territory a part of India. And therefore, taking cue from exactly this, you have Article 2, which refers to the procedure for acquisition of new territories. Article 3 refers to internal changes, which means if you are just reshuffling the territory, the area, the names of states or union territories. Article 4 is actually the background article. It is a star that says terms and conditions applied. Article 4 basically says if you're making any changes under Part 1, those changes will obviously happen to the first schedule. The first schedule is very much a part of the Constitution. Those changes will not be considered constitutional amendments under Article 368. Doesn't matter with or without ratification. So this means they've straight out put it across that it is requiring simple majority. This Article 4 is also reflective of rule number 2, center stronger than the states, which means you're not even dignifying a territorial change with any form of a heightened majority or a heightened status as far as the Constitution is concerned. So what happens over a period of time is there are certain territorial arrangements that are made, and because of those, the Supreme Court interprets certain provisions of Article 2 and creates certain exceptions to Article 4. Always remember, a Supreme Court or any court can interpret a law, can invalidate a law, can make a law operational or inoperational, but it cannot make any textual changes, even to a comma or a full stop, to any law. So the Supreme Court has interpreted Article 2 and therefore has provided for a special procedure given the nature of Article 2. Let's understand what the procedure is, and let's understand why is the procedure. So, first things first, it very clearly identifies that a parliamentary law is going to be required. Article 2 is referring to external changes, while Article 3 is referring to internal changes. Now, what is interesting about external changes is that you are either bringing territory inside or you're sending territory outside. If you're sending territory outside, that would be a part of some state or union territory. If you're bringing territory from outside, it would effectively be added or subtracted to some state or union territory. So therefore, eventually the change is going to happen to the state or the union territory whose name and area is mentioned under Schedule 1. But what is remarkable about external changes is that external changes are essentially the byproduct of governmental negotiations. So generally what will happen is there will be a government executive order finalizing the negotiations that we may have had with another country, and that executive order will then have to be implemented through a parliamentary law. That's generally the process. But the Constitution generally just talks about this. This is just additional information. Don't have to worry about it as far as the prelims is concerned. So therefore, you require a parliamentary law. Now, it doesn't matter what kind of territory. If the territory is coming to India, you would require a simple majority. Because if it's coming to India, it's a good thing. It will add territory. Therefore, we have a positive notion to having more land. More land means more resources. More resources means the ability to provide for more people. So therefore, if any form of territory, does not matter what it is coming to India, you will require simple majority as Article 4 would have had it. The problem is when you are giving away land, when you are giving away Indian land, which is a part of either a state or a union territory, to any other country. That's where a bifurcation is needed. The bifurcation is either it is disputed or undisputed. Now, why is this bifurcation important? It is important because if it is disputed territory, the union government anyways has the powers of foreign policy, so they're doing their job. But if it is undisputed territory, for absolutely no fault of the state or union territories, for absolutely no concern whatsoever, just out of sheer goodwill, if you'd like to call it that, you're giving away territory to another country. So therefore, you have two separate divisions. And because you have these two separate divisions, what will happen is the Supreme Court will give an intervention and will give an interpretation. And this interpretation comes from the in reference Berubari Union case of 1960. The Berubari Union case was a presidential reference which was made by the President to the Supreme Court under, I think, Article 143, and the Supreme Court was mandated to give a reply back because it was out of an agreement predating the Constitution. So the area of Berubari, if I remember correctly, was a part of the Jalpaiguri district of West Bengal, and there was some confusion over Berubari being a part of India but not shown on the official map, or Pakistan claiming it to be the other side, because back in the day Bangladesh was East Pakistan. So what was effectively decided is that on the basis of negotiations between the two countries, it was so decided that India will give Berubari Union to Pakistan. That's the basic idea. And if that is the basic idea, India very well had acknowledged Berubari Union to be a part of India. Berubari Union was not a disputed territory for us. We had absolutely no qualms whatsoever in claiming Berubari Union to us. So obviously the state of West Bengal was at a loss. So the Supreme Court then came in and said, you are effectively performing center stronger than the states. You are not giving away a disputed territory which you have the powers to adjudicate over. You're giving away territory which legitimately is yours. The least you can do is dignify it with a constitutional amendment under 368, but without state ratification. And without state ratification is the hollow candy. Because if it is concerning one state, I can't seek the permission of half of the whole number of states. And two, that would unnecessarily give a slight tilt of power to the states, and the ultimate idea is center stronger than the states. Now, in another case called the Maganbhai case of 1969, the Supreme Court gave an interpretation to if the territory is disputed. Now, if the territory is disputed, then you are simply doing your job. Through an executive order, you figured this out, and you are now simply going to pass it using simple majority as per Article 4. Because the Article 4 says any change which happens is not an amendment under 368, though it is amending Schedule 1. And if it's a constitutional amendment outside 368, we know we always require what is called a simple majority. Now, even in the case of an undisputed sort setup, you may have an executive order which would be prompting a constitutional change, but that's the background of it, and that's all right. Now comes Article 3, which are internal changes. Now, Article 3, which are internal changes, basically say that before you start adding or subtracting or reshuffling the areas or the boundaries or the names of the states or union territories, you will require a presidential recommendation, and you will fulfill it through a simple majority. It will amend Schedule 1, and you'll still call it a reorganization act. If it's a bunch of changes together, then the States Reorganization Act, like it happened in 1956. Or if it is a specific state, then maybe the Andhra Pradesh Reorganization Act, or maybe the J&K Reorganization Act, or even maybe say the UP Reorganization Act, and so on and so forth. Why the J&K Reorganization Act is a territorial change under Article 3 is because J&K was converted from a union territory to which had special status to a union territory which was converted from a state which had special status to a state which had no special status. So that means you were a state like any other state. So if you were a state like any other state, then provisions for any other states would also apply to you. And that's effectively what happened when it comes to Article 3. They effectively used Article 3 and they converted the state of J&K into the union territory of J&K with a legislature, not functioning today though, and a union territory of Ladakh. So you've basically converted the state into two union territories, the first time in Indian history though. And Article 4 is, as I told you, the background article. So this is generally the law. Anything more than this, I don't think is required as far as the prelims exam is concerned. Now let's quickly look at the external changes as we would know it to be. Now, effectively what happens is, there are two kinds of external changes. The special kind, as per Berubari Union's interpretation of the Supreme Court, is if you are giving away undisputed territory or literally anything else. Anything else would include, let's say you're getting disputed territory, or you're getting even undisputed territory. It absolutely does not matter. Or even if you are, let us say, giving away any form of territory which is effectively disputed in nature. So that's the important part. If territory is coming in, does not matter whether it is disputed or undisputed, absolutely requires the same majority. But if you're giving away territory which is undisputed, then you will have what is called a constitutional amendment under Article 368. So whether or not there's an executive order, a bill would be prepared, a draft constitutional amendment bill will be prepared. That bill would be changing Schedule 1. If needed, would also change Schedule 4 if needed. Now, interestingly, you will directly send it to the Lok Sabha and the Rajya Sabha, and then you would require the president to give an assent. Now, because it's a constitutional amendment, the president necessarily has to say yes, there is absolutely no other option. Which brings me to a very important question. If you are giving away undisputed territory, does that necessarily lead to a reduction in the number of seats to the Rajya Sabha? Because it would have an impact on population. It may or it may not. The constitution is silent on it. So it is generally assumed that it is going to take what is called the passage which was required to pass the law in the first place. So this is how undisputed territories are legislatively, procedurally executed. Now, anything else is like any other law. Now, what generally happens is, very interestingly, is anything else you will simply require a bill. That bill has to be sent to what is called the Lok Sabha or the Rajya Sabha. They will pass it. It's a simple majority bill. Will go to the president. The president can say yes, the president can say no, and the president can also return. Now, in the case that there are internal changes, you will prepare a bill. Before the bill is placed before the Lok Sabha or the Rajya Sabha, you will require a presidential recommendation. This is nothing but a hollow candy to the states, because the president is elected by both the center and the states. And as a symbolic gesture, the president will refer it directly to the state legislature. Now, there is absolutely no time period given whatsoever. The president can assume consent. The reference is just symbolic. If the state does not respond in a specific time period, the matter ends there. And after this symbolic process is over, because anything that the state legislatures say is not binding on the president will therefore send it to the Lok Sabha or the Rajya Sabha. And when the president will send it to the Lok Sabha or the Rajya Sabha, they will again pass it using a simple majority, send it back to the president, and the president can say yes, can say no, or can return. As you know, there are never any time periods for the president to say either a yes or a no or even return. It's generally, this is how the process is done. So basically, any territorial change apart from giving away undisputed territory requires simple majority. That's the basic underlying factor. And because territorial changes are changes that are government driven, though it's not written anywhere, most territorial changes are government bills. Nowhere in the constitution does it say that a private member cannot introduce a territorial change. If they do, because a presidential recommendation is required, it will anyways go through the Council of Ministers, because the president under Article 74 acts on the aid and advice of the Council of Ministers. So this is generally how territory works. So what happened when we started out was, we were essentially a British colony. We were essentially British administered provinces or British administered regions. After the partition, we became independent India, and we started integrating what were called princely states. Now, from here, we have reorganized India. There are essentially the following phases. The first phase is generally from 1950s till about 1980s. Now, this is the phase where you generally see multiple reasons of reorganization, but the primary reorganization that will happen will be at a linguistic level. So basically what happens is, when we become independent, we've got part A, B, C, D states. There's nothing called a union territory. This is in 1950. In 1956, we become states and union territories. And 1956 onwards, we are reorganizing states and union territories as we think best. So part A were British provinces, part B were princely states, part C were special areas, and part D only had one state called Andaman. Yes, and in 1956, of course, Andaman becomes a union territory. So the first phase from 50s till about 70s and 80s is a linguistic domination reorganization. It also leads to the birth of regional parties. It also leads to anti-defection law rising up to unprecedented levels, which is why you would effectively have the 52nd Amendment of 1985 inserting the 10th schedule. Post the 80s, you will see a very heavy focus on reorganization of the northeastern states till about early 2000s. And from 2000s onwards, you will see a smaller state cut out from a parent state. They generally speak the same language, but there are developmental, welfare, or administrative reasons that actually take precedence. So whether it is a Uttarakhand or a Chhattisgarh or a Jharkhand, the parent states that they've been cut out from, or even Telangana for that matter, has been for developmental reasons, for welfare reasons, and so on and so forth. But as far as the prelims is concerned, I think this is more than enough, and we would not require anything more than this as far as the exam is concerned. Now, quickly moving on to citizenship, some basic dimensions and key concepts. So, we first understand, because the prelims question was on basic concepts of what is called single citizenship. So how we understood the dimensions of territory, we must understand the four basic terms which are associated with citizenship. Again, you can read the detailed handout if you'd like, but honestly this is more than enough. It's a very recent question that was asked. The chances of it being asked in prelims 2024 to my mind are negligible. So there is a concept called nationality. Now there's something called a common law system, there's something called a continental law system. Now these are basically legal systems of the world that we've discussed in the first lecture, where you'll see differences of what is called the propensity of judicial review and the role of the parliament and so on and so forth. Basically the authority of the law versus the authority of the courts. In common law systems, the authority of the courts is slightly higher. In a continental system, the authority of the law, the parliament, is slightly higher. Anyway, so nationality is a moral concept. It is a philosophical concept. It basically means where you originally come from, what your roots are, what do you identify as the country that you belong to. Now, in most countries like India, nationality and citizenship is often interchangeable, but there is a theoretical difference. Nationality can never be changed, but citizenship most certainly can be. Citizenship, if nationality is a legal concept, citizenship is dominantly a moral concept. Sorry, the other way around. If citizenship, if nationality is a moral concept, then citizenship is dominantly a legal concept. Now this means that you are a member of a sovereign state. It means you are an official member of an independent country, and because of the virtue of being a member, you are entitled to certain rights, certain functions, certain accesses to certain civil and political ecosystems, which non-citizens may not. So this is what part 2 of the Constitution deals with. A closely related concept to citizenship, and you would be playing an interrelated role, is something called domicile. Now domicile has two meanings: a national domicile or a regional or a state domicile. A regional or a state domicile does not find any mention in the Constitution. In fact, it is a welfare concept. But domicile, from a national point of view, is effectively where do you intend to stay permanently. This is where you come from, this is where you want to go. What do you call your permanent home? Where do you intend to stay for the rest of your life, or generally for a large period of your life? And the reason you have a concept of a national domicile is because if you want to be a member of a country, you would want to stay in that country for a long time. In any city, any state is okay, but you want to stay in that country, which is why national domicile and citizenship are correlational. You can't be given citizenship of a country if you don't intend to stay in the country for a long time. which is why India has a concept of a single citizenship and what is called a single domicile. Now, residence, on the other hand, is where you are currently staying. What is your current place of residence? It will also have an implication to citizenship, because whenever you're looking at mass migration, for example, India has had the unfortunate witnessing of the partition. So residency has been a very important requirement to figure out citizenship centric provisions. So you will often hear of the word ordinarily resident, OR. It's generally understood to be about 6 months. It's also used in several laws in several different contexts, but this is largely how it works. What we are primarily concerned with citizenship is citizenship and national domicile, and more importantly, citizenship. Now, when we look at the two basic differentiating factors, you're either a citizen or a non-citizen. Non-citizen, foreigner, alien mean the same thing. Now, this is a difference of political status. A citizen can vote, a citizen can contest elections, a citizen can hold public office, and a citizen enjoys all fundamental rights, enjoys all legal rights, no matter what. Of course, terms and conditions to legal rights will always exist, and so on and so forth. But a non-citizen will have limited fundamental rights, cannot vote, cannot contest elections in any manner, cannot even hold public office, no matter what the case might be. So therefore, what ends up happening is the difference between a citizen and non-citizen is actually a political difference. Now, if you take a magnifying glass and we try to figure out the types of citizens, you're largely looking at residents and non-residents. Now, this is a geographical difference leading to economic implications. When we say resident, it again goes back to the concept of ordinarily resident. Do you largely spend your time in India? Around 6 months or so. You'll see this to be applicable to merchant navy people. If not, then you are a non-resident Indian. If you're a non-resident Indian, it is generally a financial implication. The Income Tax Act of India defines or gives you certain ideas of it, and non-resident Indians generally do not pay taxes in India. They will have lower property rights. They cannot even hold agricultural property under ordinary circumstances, because agriculture is a keen welfare sector for India, and if you're not majorly in India, then you're buying agricultural property for subletting purposes, and profit in agriculture is something that hasn't worked out. In fact, agricultural income is still today tax free. So therefore, there is a larger way to understand the relationship between agriculture, tax, and non-residency. Now, when we look at non-citizens, now there are three kinds of non-citizens. You're either a legal migrant, which means you have a valid passport, you have a valid visa, valid travel documents, or you're a refugee. Now, a refugee is somebody who has run away from their parent country because of fear of life, fear of property, fear of threat, and there is a 1951 UN convention on it, and India has not ratified that convention, which means India is under no obligation whatsoever to accept any refugee if we don't want to. And then there's something called an illegal migrant. An illegal migrant is effectively a criminal under law. You have illegally entered India without any travel documents. A related concept to this is internally displaced persons. They are generally those people who are moving from one part of the country to another part of the country because of some fear or threat in that part of the country. But refugees are effectively international transfers. Now, this is generally dimensions and key concepts. So this is how it works. Now, there is a differentiated mechanism. A legal migrant either comes from a friendly country or an enemy country. All countries that we don't get along with are not enemy countries. The government has to specifically identify an enemy country as an enemy country. So if you are coming from a country that we have identified as an enemy country, then you become an enemy alien or an enemy non-citizen. Which means out of the limited fundamental rights that you have, you would further not have the right against the protection against preventive detention. So these are largely the dimensions and what are called key concepts. Now, having said that, there are very important citizenship centric points that you should know. A passport is a proof of Indian citizenship, absolutely, but not having a passport necessarily is not. Aadhaar is not a proof of Indian citizenship. A PAN card is not a proof of Indian citizenship. A voter ID is definitely a proof of Indian citizenship, because if you can vote, then you are, and only Indians can vote. So yes, you are an Indian citizen. Now, having said that, let's look at the policy and the law. The general understanding here is we've got in the Constitution Part 2, which deals with Articles 5 to 11, which are your primary constitutional provisions on citizenship. Article 11 is a very interesting article, and I'll tell you in just a minute. But the Constitution is also supported in the 7th schedule in the Union List, List 1, with entry 17, empowering the Parliament to make any law on citizenship. So the Parliament makes a law called the Citizenship Act of 1955. This act, of course, gets amended multiple number of times. The most recent amendment, the most widely known amendment, if not the most recent, has been 2019, and therefore it's called the Citizenship Amendment Act 2019. Now, what is remarkable about Article 11 is it's one of those rare provisions in the Constitution where Article 11 says if the Parliament makes any law on citizenship, that parliamentary law on citizenship will override constitutional provisions on citizenship, thereby giving a parliamentary law precedence over constitutional provisions. Now, this would generally not happen as far as the case is concerned. Now, this Citizenship Act becomes your current primary law to deal with provisions of citizenship. Apart from this, the nodal agency for citizenship is not the Ministry of External Affairs, it is in fact the Ministry of Home Affairs. Because if you want to apply for citizenship or your citizenship has to be taken back, then it is the MHA who does it, because you are going to be living in India. So you're going to be part of the internality of India, and that has a law and order implication. So the MHA comes to task. Now, apart from the MHA, there are 3 executive bodies that have been set up. Now, the head executive body is the Bureau of Immigration. The Bureau of Immigration is the executive body set up under the MHA of sorts, and they are manning all immigration checkpoints. And under the Bureau of Immigration, at a regional level, maybe 2-3 states combined, you will have a foreigner regional registrations office, which will take care of any issues that foreigners are placing in that region or supervising immigration checkpoints for land, sea and air. And at the grassroots level, in case you don't have a dedicated BOI official, the district magistrates or the SPs can be foreigner registration officers. Now, if the basic principle is you have to be a legal migrant to be able to apply for citizenship, and you can apply for citizenship in 2 ways. 1, you can directly apply to the MHA, or 2, you can send an application to your nearest district magistrate. The right to citizenship has been recognized as a statutory right and a constitutional right as per the Arunachal versus NHRC case of the Supreme Court in 1996. So citizenship in that court's judgment is both a statutory right and a constitutional right, very much like property. So anyway, let's understand this from another perspective. So this becomes your law, this becomes your institutions. Now, citizenship is about the people in your country. So you need to count the number of people in your country. And for that you have something called the census. The census is a population enumeration exercise. It includes both citizens and non-citizens. It happens in multiple stages. So you can have a household stage, you can have an individual stage. The last time we had a census was in 2011. We were supposed to have one in 2021. It's a decadal exercise, but unfortunately we could not because of the pandemic. We are expecting the census to happen after the 2024 elections in a few months. And in 2011, an exercise called NPR, the National Population Register, was also conducted alongside the census. So what is the difference between census and NPR? Census is also citizens and non-citizens. NPR is also citizens and non-citizens. The difference is NPR looks at, are you staying in that area from an ordinary resident point of view? Are you ordinarily going to be residing in that area so that we can better target welfare schemes? What happened for the first time in 2011 was the fact that we had a biometric enumeration which was also taken. We had a digital enumeration exercise where the information or the collection was done digitally through a mobile device or an electronic gadget. So those have been some key ideas. The census, officially, there's a census division under the MHA, and the person who is the head of the census is the census commissioner. Now, technically the census is considered as an independent exercise, but the MHA has a census division which effectively takes care of any nodal formalities that may be required. Now, when we look at the provisions of the Constitution under Articles 5 to 11, Articles 5 to 8 deal with how do you become an Indian citizen. Articles 9 to 11 are about principles of citizenship. Now, let's understand what this is. Article 5, and again extremely irrelevant or extremely unlikely for the prelims exam. So let's just quickly run through this. Article 5 tells you how do you become an Indian citizen on 26 January 1950. So how do you become one? Remember we spoke about domicile. What we are referring to is the domicile of India or independent India, because you're talking about as on 26 January, which is the commencement date. Now the Constitution says commencement. It does not mention the date 26 January. But interpretation in the General Clauses Act refers to 26th January 1950. So as per Article 5, as on 26th January 1950, how do you become a citizen of India? Number one, you've got to be a domicile in independent India, which means you've been wanting to stay in India and you call independent India your home. This is compulsory. Then one out of the two conditions should be applied to you. Either you or your parents should have been born in the territory of independent India. They were born in the territory which is independent, which means the territory may have existed pre-independence also, but even after post-independence, that territory remains to be a part of India. Basically, you should have been born not in Pakistan or Bangladesh. Now, either this applies to you or you have been ordinarily residing in India for 5 years prior to 26th January 1950. Either of these two conditions and you can become a citizen of India as on 26th January 1950. Now, if you look at Article 6 very clearly says, if you are migrating to India from Pakistan, what are the provisions that can help you? Either you or your parents or your grandparents, They should have been born in India as India was defined under the Government of India Act of 1935. You would remember in the previous lecture on legal history, I told you it was the Government of India Act of 1935, through its ambitions of an all India federation, that for the first time gave us the territorial idea of India. So you, parents or grandparents, should have been born in the Government of India Act defined territory of India. This is compulsory. If not, and beyond this, the two conditions apply. If you're migrating before July 1948, the exact date is 19 July, not important to be memorized for the prelims, or you're migrating after 19th July 1948. Now, if you're migrating before 19th July 1948, then you should have been ordinarily residing in post-independent India or independent India since the time you've migrated. Suppose you've migrated in 1949. Since 1949, you have been effectively living in India if you were a migrant from Pakistan to India. Now, that's the case if you've, this is pre-July 1948 or post-July 1948. So if you've migrated to India pre-July 1948, then you should have ordinarily been residing 5 years since 1950. But if you've migrated to India after July 1948, that's when an official agreement was signed between the two countries. Post July 1948, then it has to be on a case-by-case basis. A special application has to be made by you, and on the basis of that special application, you would be granted citizenship by a government official if you have migrated after July 1948. But that application should have been made before 26th January 1950. That's the basic idea. Now, so pre-July 1948 or post-July 1948, the basic difference is pre-July you've ordinarily been residing for about since you've migrated, or post-July on a case-by-case basis, and that's the difference part. That's the differentiating part, which is pre-July 1948, you don't have to make an application. You have to just go through a process. But post-July 1948, you do have to make an application. This is Article 6. We move to Article 7. Article 7 deals with if you've migrated from India to Pakistan, didn't quite like it there, and now you're coming back to India. If that's the case, then no Indian citizenship will be granted to you if you have migrated to Pakistan after March 1947, unless a special permit has been issued to you and on a special case-by-case basis you have been allowed to come to India. So what about before 47? Then the prior provisions would apply as per Article 6 anyway. Now, Article 7. This takes care of the non-partition provisions. Article 7 is very, very interesting. Article 8 talks about if you are residing in any part of the world except Pakistan, which includes Pakistan and Bangladesh, you, your parents, your grandparents would have been born in India as per 1935, and very simply, you can go to the nearest embassy or the consulate and get yourself registered. Very simple, Article 8. Now, Articles 9, 10 and 11 largely speak about two things. We shall have a single citizenship. There shall only be a domicile of India. At a regional level also, you can only have a domicile of one state, but that's nothing to do with the constitution. And the parliament can make any law in continuation of this, and that parliamentary law will override the provisions of effectively Part 2, which contains citizenship. Now, the actual Citizenship Act, the final part of this. See, the Citizenship Act speaks to you about two things. One, how do you become an Indian citizen? And how can your citizenship be lost? It also reiterates the principle of single citizenship, and that's okay. At the most, what you need to know are current basic provisions without too much technical detail. There are 5 basic ways: birth, descent, registration, naturalization, and incorporation. So when we refer to birth, what do we refer to? A, you were born in India, and if you were born, and this is as of today, so the amendment happened in 2003, was in effect from December 2004. So basically, from December 2004, these are your birth provisions. A, you've got to be born in India. B, one of your parents has to be an Indian citizen. And C, the other cannot be an illegal migrant. This saw some ramifications because of the Citizenship Amendment Act of 2019, but that's not the relevant part as far as your prelims is concerned. This is it. As far as descent is concerned, you are born outside India, and when you were born, at the time that you were born, one of your parents is an Indian citizen. This has been the law since, if I remember correctly, 1992 onwards, and you have to compulsorily register yourself with the nearest Indian consulate and give up a citizenship if you already have of that country, and the process can be undertaken. Registration is a fairly detailed process. There are multiple conditions. For example, you could be a PIO, or a PIO residing in India for about 7 years. You could have married an Indian. Your parents could have been Indian. You could have been Indian. There are several cases. Please do not memorize this for the prelims exam. A PIO, for the understanding of registration, simply means a person or their parents who were born in undivided India or even in independent India, which means you would have, could have, should have become an Indian citizen if you could, or if you wanted to. Naturalization is effectively discretion of the central government. There are provisions. Some of them are, for example, you've lived in India for about 11 years, or you served the government, or you have a good character, you speak a language. It's a combination of factors. And lastly, what you have is incorporation. For example, when the land boundary agreement happened, we gave some enclaves to Bangladesh, we got some enclaves back. That would require an express grant of citizenship to the enclaves that we got. Incorporation, in a way, is an extension of naturalization to begin with, right? Now, as far as giving up citizenship is concerned, 3 things. 1, you voluntarily have decided, I've got another citizenship, I want to say by renunciation. 2, the government found out that you were juggling 2 citizenships. So they said, please go, we don't want you to be an Indian citizen. That's termination. 3, you've lied on your citizenship application, or some documents about you are untrue. So this is how you would lose Indian citizenship. If at all there has to be a question, I would definitely say there could be a question on certain basic factors or certain basic facts concerning the census, because the socio-economic caste census was actually in the news. And that's something that is too political to be asked in the prelims exam, but census could definitely be asked no matter what the case. So this is lecture number 4. Now I see you for the grand lecture, lecture number 5, which is the preamble, rights, duties, and directive principles, along with sectoral reviews of the related issues. Thank you. Keep watching. See you in the next class.